gives private citizens the right to possess a firearm, including a pistol.
The core mission is to prevent and protect the American people from violent crime.
One of the students in my school brought 3 guns to school, and our entire school went on lockdown.
A constitutionally protected industry would know something about firearms.
That's not a right of government. That's a right that each of us has as Americans.
There are approximately 40 million firearms with stabilizing braces currently in circulation.
Breaking news, this November the Supreme Court will hear the following significant Second Amendment case. Supreme Court to hear Second Amendment case with far-reaching implications. The Supreme Court announced that it will hear New York State Rifle and Pistol Association, Inc. versus Corlett, a case that could transform the judiciary's understanding of the Second Amendment and lay waste to many of the nation's gun laws. The case involves New York State's handgun licensing law, a law that has been in place since 1913, which requires someone who wishes to carry a handgun in public to demonstrate proper cause in order to obtain a license permitting them to do so. Proper cause can be demonstrated in several ways. Someone who wishes to use a gun for hunting or target practice may obtain a license permitting them to do so, although this type of license can be restricted to only allow the bearer to use their gun for these purposes. People in certain kinds of work may also obtain licenses. A storekeeper might be issued a limited license, allowing them to keep a gun in their store for protection, for example, or a bank messenger may be allowed to carry a gun to protect themselves and the money they transport. However, in order to get a license to carry a firearm without any restrictions, the courts of New York have mandated that an applicant demonstrate a special need for self-protection distinguishable from that of the general community or of persons engaged in the same profession. Someone who just wants to carry a gun because they have a broad belief that it would be useful in the event that they are ever the victim of a violent crime is unable to receive a license. However, someone who wants to carry a gun because they have a particular fear of their stalker may be able to obtain a license. In the case of Corlett, the plaintiffs include a gun rights organization from the state of New York, as well as 2 men from the same state who requested for a license to carry a pistol in public but had their request denied. They argue that law-abiding citizens have the right under the Second Amendment to carry a gun in public, and the Supreme Court, which currently has a conservative majority of 6-3, might find itself in agreement with them.
Earlier this year, the ATF issued a rule that unilaterally puts new restrictions on Second Amendment rights.
Gives private citizens the right to possess a firearm, including a pistol.
In point of fact, Corlett has the potential to overturn more than a decade's worth of judicial rulings that have interpreted the Second Amendment. This would place prohibitive constraints on the ability of lawmakers to lessen the incidence of gun violence. In fairness, there is one early sign that the court may be inclined to place some limits on its decision in Corlett. Although the plaintiffs asked the court to rule on a broad question, whether the Second Amendment allows the government to prohibit ordinary law-abiding citizens from carrying handguns outside the home for self-defense, the justices announced on Monday that they will only resolve a more narrow question, whether the state's denial of petitioners' applications for concealed carry licenses for self-defense violated the Second Amendment. Nevertheless, this narrower question is still broad enough to allow the Supreme Court to rewrite a decade of Second Amendment precedents, to unwind a consensus within the lower courts that permits many gun regulations to stand, and then to allow those lower courts to complete the process of dismantling other gun laws. Evolution of Second Amendment jurisprudence, from militias to individual rights. The Second Amendment provides that a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed, and until fairly recently, the Supreme Court took the first 13 words of this amendment very seriously. As the court explained in the United States v. Miller, 1939, the obvious purpose of the Second Amendment was to render possible the effectiveness of militias. Thus, the amendment must be interpreted and applied with that end in view. But the Supreme Court largely abandoned this approach in its 2008 decision in District of Columbia v. Heller, holding for the first time that the Second Amendment protects an individual's right to bear arms. While Heller marked a sea change in the court's approach to the Second Amendment, it was also a heavily caveated victory for gun rights advocates. Among other things, Heller suggests that bans on carrying concealed weapons are lawful, as are long-standing prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places such as schools and government buildings, or laws imposing conditions and qualifications on the commercial sale of arms, or bans on dangerous and unusual weapons. Additionally, while Heller struck down the District of Columbia's absolute prohibition of handguns held and used for self-defense in the home, the opinion is much less clear about gun rights outside the home. Since Heller, the Supreme Court has largely been silent about the scope of the Second Amendment, handing down only one significant Second Amendment decision, McDonald v. City of Chicago. The case merely held that states, and not just the federal government, are bound by the Second Amendment's restrictions on gun laws, whatever those restrictions may be. And yet, while the Supreme Court has largely stayed out of the business of interpreting the Second Amendment since Heller, a clear consensus has emerged in the lower courts regarding how to interpret that amendment, even though this consensus is not shared by many key members of the Supreme Court.
A pistol brace is also known, this scary piece of equipment here.
The core mission is to prevent and protect the American people from violent crime.
Lower federal courts' consensus approach to Second Amendment cases. In the absence of more guidance from the Supreme Court on how to apply the Heller decision, lower federal courts have largely coalesced around the same basic approach to Second Amendment cases. At least 10 federal appeals courts apply what federal appellate judge Stephen Higginson describes as a two-step analytic framework. Under this framework, severe burdens on core Second Amendment rights are subject to strict scrutiny, the most skeptical level of review in most constitutional cases. Meanwhile, less onerous laws, or laws that govern conduct outside of the Second Amendment's core, are subject to a more permissive test known as intermediate scrutiny. Under this consensus framework, gun regulations that impose very serious restrictions on core Second Amendment rights, which Higginson describes as the right of law-abiding, responsible citizens to use arms in defense of hearth and home, that the court recognized in Heller, but may also include some guns rights that were historically considered important, will be typically struck down, while less severe restrictions or gun laws that don't burden the Second Amendment's core are more likely to be upheld. In 2012, the United States Court of Appeals for the Second Circuit applied this framework to the gun licensing regime at issue in the Corlett case, and it upheld that regime. In an opinion by George W. Bush appointee Judge Richard Wesley, the Second Circuit explained that there is a long tradition of laws in the U.S. that prevent people from carrying guns outside of their homes. During the founding era, Wesley wrote, many states prohibited the use of firearms on certain occasions and in certain locations. North Carolina, for example, forbade going armed at night or day in fairs, markets, nor in the presence of the king's justices or other ministers, nor in no part elsewhere. In the 19th century, Georgia and Tennessee banned outright the sale of weapons, such as handguns, that could be concealed. And New York's own licensing regime is more than a century old. In light of this history, the Second Court concluded that state regulation of the use of firearms in public was enshrined within the scope of the Second Amendment when it was adopted, and thus a licensing regime for people who want to carry firearms in public did not fall within the core of the Second Amendment. Dissenting voices among lower court judges. While lower court judges have largely embraced the two-step analytic framework applied by most circuits, there have been a few dissenters. One dissenter is Justice Brett Kavanaugh, who argued in a 2011 dissenting opinion when he was still a lower court judge that the consensus approach should be abandoned. Courts are to assess gun bans and regulations based on text, history, and tradition, Kavanaugh claimed, not by a balancing test such as strict or intermediate scrutiny. In that 2011 case, Kavanaugh would have struck down a law banning semi-auto assault weapons and requiring gun owners to register their firearms. Justice Amy Coney Barrett, meanwhile, also called for a stricter Second Amendment when she was a lower court judge. Recall that Heller suggested that long-standing prohibitions on the possession of firearms by felons and the mentally ill are constitutional, but dissenting in Cantor v. Barr 2019, Barrett claimed that this rule should be shrunk so that only dangerous people may be prohibited from owning a gun. So under Barrett's framework, a person convicted of a non-violent felony like mail fraud would still have a Second Amendment right to own a gun. There's also a third reason to suspect that the Supreme Court is likely to use the Corlett case to move the law dramatically to the right. Shortly before his death in 2019, retired Justice John Paul Stevens revealed some of the internal deliberations behind the Supreme Court's Heller decision. After former Justice Antonin Scalia, the author of Heller, circulated his original draft to the court, former Justice Anthony Kennedy asked for some important changes to that draft. Because Heller was a 5-4 decision, Scalia needed Kennedy's vote to hold onto his majority. According to Stevens, it was Kennedy who requested that the opinion include language stating that Heller should not be taken to cast doubt on many existing gun laws. But Kennedy retired from the Supreme Court in 2018 and was replaced by Kavanaugh. And Justice Ruth Bader Ginsburg, who joined the dissent in Heller, died in 2020 and was replaced by Barrett. The current court, in other words, is much more conservative than the court that decided Heller in 2008. It's not even clear that a majority of the current court supports the portions of Heller that limit the scope of the Second Amendment, much less the kind of analysis that led the Second Court to uphold New York's gun licensing law. The future of gun control in the U.S. could be quite grim, and Corlett could mark the moment when lawmakers' power to fight gun violence falls apart.
Yeah, when I was in 11th grade and Joe Biden made our schools gun-free school zones.
A constitutionally protected industry would know something about firearms.
One of the students in my school brought 3 guns to school, and our entire school went on lockdown.
Supreme Court's November 2023 argument calendar. A major Second Amendment dispute and a challenge to the constitutionality of efforts by public officials to block constituents on social media headline the Supreme Court's November argument calendar. The session, which begins on October 30, is a relatively light one, with the justices scheduled to hear oral arguments in just 7 cases over 6 days. The justices will hear oral argument in O'Connor-Ratcliffe v. Garnier and Linkey v. Freed, the social media cases, on October 31, the only day on which they will hear arguments in 2 cases. Both cases, which stem from different lawsuits, arose after public officials, members of a local school board, and a city manager blocked parents and a resident who criticized them for their personal social media accounts. A federal appeals court in California ruled that the board members' blocking of the parents constituted action by the government and therefore violated the First Amendment. But a federal appeals court in Ohio disagreed. It held that because the city manager did not operate his Facebook page as part of his job, he did not violate the First Amendment when he blocked the resident. The Supreme Court agreed to weigh in earlier this year. The justices will hear oral argument on November 7 in United States v. Rahimi, a challenge to the constitutionality of a federal ban on the possession of guns by individuals who are subject to domestic violence restraining orders. The question comes to the court in the case of Zaki Rahimi, a Texas man who became the subject of a restraining order after a 2019 argument in which he knocked his girlfriend to the ground and dragged her back to his car. A year later, after police found guns and ammunition in his house, he was charged with violating the federal ban. Rahimi pleaded guilty and was sentenced to just over 6 years in prison, and a federal appeals court in Texas initially upheld his conviction. But in the wake of the Supreme Court's 2022 decision in New York State Rifle and Pistol Association v. Bruin, striking down New York's handgun licensing scheme, the Court of Appeals issued a new opinion that threw out Rahimi's conviction. The Biden administration asked the justices to take up the case, which they agreed to do this summer. Here is the full list of cases scheduled for argument in the November 2023 argument sessions. Cully v. Marshall, October 30. What test should district courts apply to determine whether a state or local government must provide a hearing to someone who has had property seized under a civil asset forfeiture law? O'Connor-Ratcliffe v. Garnier and Linkey v. Freed, October 31. Are public officials acting as government officials so that they can violate the First Amendment when they block people on their personal social media accounts that they use to communicate with the public? Vital v. Elster, November 1. Does Section 2C of the Lanham Act, which bars the registration of a trademark which uses the name of another living person without that person's permission, violate the Constitution when used to reject a trademark that contains criticism of a government official or public figure? Department of Agriculture v. Kurtz, November 6. whether the civil liability provisions of the Fair Credit Reporting Act clearly waive the sovereign immunity of the United States. United States versus Rahimi, November 7. Whether a federal ban on the possession of guns by individuals who are subject to domestic violence restraining orders violates the Second Amendment.
The Second Amendment to the United States Constitution, Mr.
Because he was the only person with a gun. There was no good guy with a gun.
Rudisill versus McDonough, November 8. Whether a veteran who has served 2 separate periods of qualifying service under the Montgomery GI Bill and the post-9/11 GI Bill is entitled to receive a total of 48 months of education benefits as between both programs. Supreme Court to review Second Amendment case, U.S. versus Rahimi. The Supreme Court is set to hear and make a crucial decision in a new Second Amendment case, U.S. versus Rahimi, before the end of their next term. This case has garnered attention as the government actively sought Supreme Court review due to a recent ruling by the Fifth Circuit, which declared that the Second Amendment is not unconstitutional. The central issue in this case revolves around the Bruin analysis, which asserts that any government limitation on the right to keep and bear arms must have historical grounding or precedent dating back to 1791. If such a precedent is lacking, the statute in question must be declared unconstitutional and repealed. The Supreme Court's decision in this case will have significant implications for future cases, offering further clarification on how the Bruin analysis should be applied. This clarification is essential to prevent lower courts from potentially misapplying the analysis, similar to the aftermath of the Heller decision. The people and the Second Amendment. A particularly intriguing aspect of this case is the Supreme Court's examination of who constitutes the people as mentioned in the text of the Second Amendment. This scrutiny promises to shed light on the scope and applicability of the Second Amendment in contemporary contexts.
So many people who are opposed to the Second Amendment. That's not a right of government. That's a right that each of us has as Americans.
Case background and Mr. Rahimi. However, it's important to note that the underlying facts of this case are far from favorable. Mr. Rahimi, the defendant in this case, is not a person of good character, and it is evident that he should have faced charges and convictions under other laws. Between December 2020 and January 2021, Mr. Rahimi was involved in a series of alarming incidents, including multiple slayings in and around the Arlington, Texas area. On December 1st, he sold narcotics to an individual and subsequently fired multiple shots into that individual's residence. The following day, after being involved in a car accident, Mr. Rahimi reportedly exited his vehicle and fired shots at the other driver involved in the accident. He then fled the scene, returned in a different vehicle, and once again opened fire on the other driver's car. On January 7th, Mr. Rahimi fired multiple shots in a Whataburger restaurant after his friend's credit card was declined. Law enforcement officers in the Arlington area swiftly identified Mr. Rahimi as the suspect involved in these multiple slayings and the Whataburger incident. They secured a warrant for his home, where they discovered numerous rifles and pistols. Mr. Rahimi admitted to ownership of these firearms and confessed to being subject to a civil protection order issued in February 2020. The protection order effectively barred him from stalking, threatening, and harassing his ex-girlfriend and their child. It also clearly forbade Mr. Rahimi from owning any firearms going forward due to his prior possession of firearms. A federal grand jury indicted Mr. Hume for possessing a firearm while under a domestic violence restraining order in violation of Federal Law 18 U.S.C. Section 922 G8. This federal law is the focal point of the case in question. Mr. Rahimi's challenge and legal proceedings. Early in his case, he brought a challenge against that aspect of the federal law, arguing that it was unconstitutional under the Second Amendment. However, he lost that argument, as prior Fifth Circuit precedent had found, using an interest-balancing approach, that this piece of federal law was indeed constitutional. He then appealed this decision to the Fifth Circuit, which once again found that his argument was foreclosed due to their prior precedent.
Except with the ATF, they don't even claim to be experts.
So the shooter can shoot the pistol with one hand.
However, a significant development occurred when the Supreme Court issued their 6-3 decision in Bruin. This decision reaffirmed that an analysis based on the text as informed by history and tradition is the proper approach, as opposed to interest balancing. Consequently, the Fifth Circuit precedent that had previously upheld the constitutionality of the federal law in question was essentially struck down and overruled. Subsequently, the Fifth Circuit panel withdrew their prior opinion and reanalyzed the case in light of the Bruen decision. They concluded that under Bruen, their previous precedent was no longer valid. As a result, they determined that this piece of federal law, which prohibited firearms and ammunition possession for individuals subject to a domestic violence restraining order, violated the Second Amendment. Fifth Circuit's analysis and ruling. The Fifth Circuit panel scrutinized the government's position and found that the government failed to demonstrate that Section 922G8's restriction on the Second Amendment right aligned with our country's historical tradition of firearm regulations. They also determined that the government's analogies did not hold up under one or both of the metrics outlined by the Supreme Court in Bruen, which serve as the baseline for measuring relevantly similar analogs. Additionally, the panel concluded that these regulations placed a burden on law-abiding citizens' rights to keep and bear arms for self-defense. As a result, they deemed this section of federal gun control unconstitutional and vacated Mr. Rahimi's conviction for possessing a firearm in violation of that law. Naturally, the government and anti-gun advocates were not pleased with his outcome. In response, they decided to take an unconventional route. Instead of seeking en banc panel review in the Fifth Circuit, they opted to bypass that step and directly requested the Supreme Court to review the case. This decision underscored the significance of the matter at hand. The Supreme Court's decision will necessitate the application of the Bruen analysis in Section 922G8. This implies that we will gain further insights into the criteria for evaluating whether gun control laws, such as this one, meet the text and history standard set out in Bruen or fall short. This case and its subsequent ruling will revolve around the interpretation of the phrase, "the people," as mentioned in the text of the Second Amendment, which carries substantial significance. Scheduled oral arguments. In a recent development, we learn that the Supreme Court has scheduled oral arguments in the Rahimi case for November 7, 2023. This underscores the importance of the case and the anticipation surrounding the court's decision. In just a few months, the Supreme Court is set to hear oral arguments regarding the constitutionality of 922G8 and the implications of the Bruen decision for this particular area of federal law. If you've never followed Supreme Court oral arguments or haven't had the chance to listen to them before, it's worth noting that these arguments are often live streamed. During the oral arguments, each side is given approximately 30 minutes to present their case, and petitioners are normally given the option to reserve some time for rebuttal. You should brace yourself for the justices to ask the attorneys a great deal of hypothetical questions. Those who are not familiar with the format of oral arguments may find this unsettling because the justices regularly interrupt the attorneys and offer challenging hypothetical questions. The justices, on the other hand, are employing this strategy on purpose so that they can investigate the boundaries of the arguments and locate the flaws in the case. During the oral arguments, one of the factors to keep an eye on is the behavior of particular justices, specifically Kavanaugh, Barrett, and Roberts, as well as the questions that they ask. As a result of recent events, Justices Barrett and Roberts have decided to side with the liberal justices in their support of the pistol brace rule that is enforced by the ATF.
This rule redefined firearms with stabilizing braces.
Is added another piece that grips the handgun.
There are approximately 40 million firearms with stabilizing braces currently in circulation.
As a result, it will be quite interesting to see Barrett and Kavanaugh's lines of questioning as well as their overall strategy. They are frequently the wild cards in many situations, and Rahimi's oral arguments might give some light on their stances and points of view. The complex nature of the case. It's important to acknowledge that Rahimi is not a perfect case, and there might be reservations about the facts, arguments, and the plaintiff involved. Ideally, one would hope for stronger elements in a case of this significance. However, given the current circumstances, this is the case that is scheduled for Supreme Court review on November 7th. As observers, all we can do at this point is prepare to listen to the arguments. Despite any reservations, Rahimi's oral arguments may provide valuable insights, into the ongoing evolution of Second Amendment jurisprudence. That's all for this video, folks. Thank you so much for watching, and we will see you the next time.